Welcome to today's podcast, Pro Bono Profiles, where we get in conversation with iProbono's panel lawyers for insights on pro bono lawyering and their motivations to incorporate pro bono work in their practice cutting across geographical and subject matter jurisdictions. We have Advocate Anubha Rastogi, iProbono's panel lawyer in Mumbai, joining us today to talk about her experience of representing children's rights, access to justice, and sexual and reproductive rights matters in Mumbai. I'm Advocate Amla Shezwadkar, Program Officer at iProbono, and I will walk you through this conversation. Welcome, Anubha. Could you take a moment to introduce yourself and the impactful work you've been doing?
Hi, this is Anubha Rastogi. I am a lawyer and I've been practicing for the last 20 years. A lot of my work revolves around access to justice, especially for women and minors. And I have a lot of special interest in access to sexual and reproductive health rights and services. I have been empaneled with iProbono for the last 3 or 4 years. And there's been a lot of different kind of work that I've been doing with iProbono, covering from POCSO to labor rights, and also really looking at systemic issues while dealing with access to justice for minors from the criminal code.
Thank you, Anubha. Can you give our audience a peek into the kinds of challenges you faced and what keeps you so dedicated to this work?
I think accessibility, and I don't just mean physical accessibility, but justice system being accessible and being something that can be understood by the people who want to access justice, I think is a really huge obstacle, because there is just so much process and procedure that happens, and there is so much time that goes before you can actually get an order or get some relief, whatever it is that one is looking for, that it does take away your zeal, your intent to actually approach the courts and fight for your rights. As a lawyer, when that's the kind of people you are representing, your job becomes even more difficult, because you also have to consistently keep the morale of your client up and keep making them believe that yes, it will take time. It is a system which is taking time, but it is worth the fight. It is worth the wait. I think the other aspect, especially when you're dealing with offenses and crime, is the different stakeholders that one has to deal with, like the police, like not only the court, but even paralegals, medical service providers. There's so much more bias, so much more red tapeism. There's so much more maybe a violation again that takes place, which also, I mean, really makes people question that why did I even come to court? I should have just let, I mean, something has happened to me and I should have just let that be. So, in that scenario, to keep pushing people and saying that no, once you've done this, you must try and see the end of it and, make your case wherever it's required. I think keeping that up for your clients is the most important and the most difficult part.
What is your perspective on how justice is currently delivered in Mumbai courts in child protection cases, and what reforms do you think could be beneficial for it?
So we have moved a lot in the right direction. There are a lot of systemic changes that have happened. There are a lot of physical changes that have happened. There are vulnerable witness rooms now, especially in cases of POCSO. You know that there's a special court, and there's trainings that have taken place. But despite all of that, there is a lot that is still required to be done. One has ensured that within the courtroom there may be no interaction or intimidation, but that's not the truth just outside the courtroom. There needs to be a lot more work done on the overall experience that a person, a survivor or a victim has, who has undergone some kind of sexual abuse, or the experience that that person has of the justice system needs to drastically improve.
What is the prevailing attitude of judges and other stakeholders towards defense counsels and counsels representing victims in child protection cases in Mumbai?
It will differ from judge to judge, frankly. There have been cases where judges are sensitive and give the space and time to the counsel for the victim, especially at stages which are critical. For example, bail and anticipatory bail, framing of charge or a discharge application, they will give that kind of space. While some other judges would say that it suffices if you file written submissions and you don't really need to address the court because the prosecutor has done that. And there would be a whole third lot of judges who would actually view you with suspicion. And that would really vary from case to case depending on who the accused is, what are the facts of the case, and all of that. And again, similarly for the defense lawyers, I think, again, I wouldn't want to make a generalized statement. I think it would differ from case to case, from judge to judge, and would really also depend on what the facts of the case are. And I think largely what really makes a huge difference is that despite whatever the facts are, how much as a lawyer are you being truthful, being respectful of the profession that you are in, and you're not just going to any length simply to protect your client or to make your client's case. I think that makes all the difference in terms of how the bench looks at you.
It's a common observation in Mumbai that many POCSO matters haven't even progressed to the evidence stage. What is your opinion on what are the root causes of these delays?
I've always had a reservation about expediting certain kinds of matters while the rest of the system lags behind. And that has also usually been my concern with, say, fast track courts or special courts, etc. Because according to me, the whole system needs to speed up. Then, within that speed, if you say that, okay, certain kinds of cases need to finish faster because of the kind of offense it is, the kind of witnesses involved, that does make sense. But in a system which is otherwise lagging behind, to just keep pushing for certain kinds of cases to go ahead, I think is very concerning. Coming to your specific question, I mean, I think there needs to be some revisiting of the timelines that one places in law with based on the reality that really is there of the system. While of course I know that there have been cases, for example, the Bihar case where the court started and finished the trial in 1 week flat. So then we have that extreme. So I think we need to really strike a balance somewhere.
You talked about how we view sexual activity involving minors with the lens of criminality. To what extent do you think this criminalization within the framework itself acts as a barrier?
Absolutely. I mean, I think when we are approaching this entirely from the point of view or from the context of things being wrong, I think the space in any case has really narrowed down for you to then explore, ask questions, clarify doubts, or even just seek information. Because already the context is that, oh my God, this is something wrong. This is not correct. This is against the law. So then obviously I'm not going to have the courage to actually ask or seek information openly. And so then one has no idea of what's the kind of information that any person will get. More than anything, information is the most important aspect, be that in the form of sex education in schools, or where it's okay and it's easy and it's that kind of a space where parents can speak to their children, or elders can speak to the young ones about how what really happens, and what's this feeling, and what's this change, and how do you deal with it, and all of that. But when we have only cloaked it in criminality, then we really close all spaces for any conversation, and it's just all wrong there. And so then everything only happens clandestinely or chupke se. And then obviously then there is no space for anyone to actually ensure the concept of consent, concept of personal space, and what's okay, what's not okay. I mean, all of that is not there because according to law, everything's not okay. So then there is no conversation of someone understanding how to articulate where you want someone to stop, because otherwise, I mean, everything is wrong.
Thank you, Anuba, for taking the time to talk with us about your impactful work. Join us on the next episode with Advocate Gauri Puri, iProbono's panel lawyer from Delhi, as she discusses her work on housing rights and providing representation to Basti residents. See you next time.